The correct answer is B. Liberal intellectual directives is not a directive principle of state policy. The directive principles of state policy are a set of guidelines for the central and state governments of India to follow in the framing of their policies. They are not enforceable by the courts, but the government is expected to keep them in mind while making laws and policies. The directive principles are divided into three categories: socialistic directives, Gandhian directives, and liberal intellectual directives. The socialistic directives focus on ensuring social justice and equality. They include directives such as the promotion of welfare of the people, securing of equal justice and free legal aid, and prevention of concentration of wealth and means of production to the common detriment. The Gandhian directives focus on the development of rural areas and the empowerment of the poor. They include directives such as the prohibition of intoxicating drinks and drugs, and the promotion of cottage industries. The liberal intellectual directives focus on the freedom of thought, expression, and association. They include directives such as the promotion of international peace and understanding, and the separation of the judiciary from the executive. Hence, the liberal intellectual directives are not a directive principle of state policy. The correct answer is D. Ministers do not hold office during the pleasure of the President. The President appoints the Prime Minister, but the Council of Ministers is appointed by the Prime Minister with the consent of the President. The Council of Ministers is collectively responsible to the Lok Sabha. This means that the Council of Ministers must have the confidence of the Lok Sabha, and if it loses the confidence of the Lok Sabha, it must resign. The ministers hold office during the pleasure of the Lok Sabha, not the President. This means that the Lok Sabha can remove a minister by passing a vote of no confidence. The President cannot remove a minister without the consent of the Lok Sabha. So the statement that ministers hold office during the pleasure of the President is not correct. Here is a table summarizing the relationship between the President, the Prime Minister, and the Council of Ministers. Office, appointed by, holds office during the pleasure of. President, elected by an electoral college, no one. Prime Minister, appointed by the President, Lok Sabha. Council of Ministers, appointed by the Prime Minister with the consent of the President, Lok Sabha. The correct answer is A. The emergency provisions of the Indian Constitution have been borrowed from the Weimar Constitution of Germany. The Weimar Constitution was adopted in 1919. After the end of World War I, it was a very democratic constitution, but it was also very unstable. There were many political parties, and they often disagreed with each other. This led to a lot of instability, and eventually to the rise of Adolf Hitler and the Nazi Party. The framers of the Indian Constitution were aware of the problems with the Weimar Constitution, and they wanted to avoid them. They borrowed the emergency provisions from the Weimar Constitution, but they made some changes to them. For example, they made it more difficult for the President to declare an emergency. The emergency provisions of the Indian Constitution have been used 21 times since the Constitution was adopted in 1950. The most recent time was in 2019, when the President declared a national emergency due to the COVID-19 pandemic. Here are the different types of emergency provisions in the Indian Constitution. National emergency, Article 352. This is declared when there is a threat to the security of India or its territory. President's rule, Article 356. This is declared when the President is satisfied that the government of a state cannot be carried on in accordance with the provisions of the Constitution. Financial emergency, Article 360. This is declared when the President is satisfied that a financial emergency exists. The emergency provisions have been controversial since they were first introduced. Some people argue that they are too powerful and can be used to suppress dissent. Others argue that they are necessary to protect the country from threats. The Election Commission of India does not conduct the election to the office of the Speaker of Lok Sabha. The Speaker is elected by the members of the Lok Sabha themselves. The other options, the office of the President, the office of the Vice President, and the state legislature and union territory, are all conducted by the Election Commission. Here is a table summarizing the elections conducted by the Election Commission of India. Election conducted by Election of the President, Election Commission of India. Election of the Vice President, Election Commission of India. Election to the Lok Sabha, Election Commission of India. Election to the Rajya Sabha, Election Commission of India. Election to the State Legislative Assembly, Election Commission of India. Election to the Union Territory Legislative Assembly, Election Commission of India. Election to the Panchayats, State Election Commissions. Election to the municipalities, State Election Commissions. The Election Commission of India is an independent body that is responsible for conducting all elections in India. It is headed by the Chief Election Commissioner, who is assisted by 2 election commissioners. The Election Commission is responsible for ensuring that all elections are free and fair. The correct answer is A. Chief Justice J.S. Khehar headed the 9-judge constitutional bench that declared the right to privacy as a fundamental right. The judgment was delivered on August 24, 2017, in the case of Justice K.S. Puttaswamy vs. Union of India. The other judges on the bench were Justice Justi Chelameswar, Justice S.A. Bobde, Justice D.Y. Chandrachud, Justice Abdul Nazir, Justice Rohinton Nariman, Justice R.K. Agrawal, Justice Abhay Manohar Sapre, Justice Sanjay Kishan Kaul. The judgment was a landmark decision that recognized the right to privacy as an essential part of the right to life and liberty guaranteed by Article 21 of the Constitution. The judgment has been hailed as a major victory for privacy rights in India. The correct answer is D. The Constitution of India is federal in form, but unitary in spirit. This means that the Constitution has the features of a federal system, such as a division of powers between the central government and the state governments, but it also has some features of a unitary system, such as the power of the central government to intervene in the affairs of the state governments. The reason for this is that the framers of the Constitution wanted to create a strong central government that could be relied upon to maintain national unity and integrity. However, they also wanted to give the state governments some degree of autonomy so that they could be responsive to the needs of the people. The Constitution has a number of features that reflect its federal nature. These include a division of powers between the central government and the state governments, a bicameral legislature, with a lower house, the Lok Sabha, elected by the people, and an upper house, the Rajya Sabha, elected by the state legislatures. A federal judiciary, with the Supreme Court at the apex. The Constitution also has a number of features that reflect its unitary nature. These include the power of the central government to intervene in the affairs of the state governments, the power of the president to dismiss a state government, the power of the parliament to make laws on any subject, including subjects that are listed in the state list. The Constitution of India is a unique blend of federal and unitary features. This has helped to ensure that the country has a strong central government that can maintain national unity and integrity, while also giving the state governments some degree of autonomy so that they can be responsive to the needs of the people. The Chief Election Commissioner of India can be removed from office by a resolution passed by both houses of parliament with a 2/3 majority in each house on the grounds of proved misbehavior or incapacity. The answer is D. The Constitution of India, Article 324(5), states that the Chief Election Commissioner can be removed from office by the President on the basis of a resolution passed to that effect by both houses of parliament with a 2/3 majority in each house on the grounds of proved misbehavior or incapacity. The other options, the Union Council of Ministers and the President of India, do not have the power to remove the Chief Election Commissioner from office. The Chief Election Commissioner is an independent constitutional authority who is responsible for conducting all elections in India. She is appointed by the President of India, but cannot be removed by the President without the consent of Parliament. This is to ensure that the Chief Election Commissioner is able to function independently and without fear of interference from the government. The removal of the Chief Election Commissioner is a serious matter, and it can only be done if there is clear evidence of misbehavior or incapacity. The resolution to remove the Chief Election Commissioner must be passed by a two-thirds majority in both houses of Parliament, which means that it must have the support of a majority of the members of both houses. This ensures that the removal of the Chief Election Commissioner is a decision that is taken by the elected representatives of the people, and not by the government. The Supreme Court of India was set up under the Regulating Act of 1773. So the answer is C. The Regulating Act was an act of the Parliament of Great Britain that was passed in 1773. It was the first major piece of legislation that was passed to regulate the East India Company's rule in India. The Regulating Act established a Supreme Court of Judicature at Fort William in Calcutta. The court had original and appellate jurisdiction over civil and criminal cases. It also had the power to try cases involving Europeans and Indians. The Supreme Court was the highest court in India until the independence of India in 1947. It was then replaced by the Supreme Court of India, which was established under the Constitution of India. The other options are incorrect. The Pitt's India Act was passed in 1784. The Indian Council Act of 1861 and the Indian Councils Act of 1892 were both passed to reform the Indian councils, which were advisory bodies to the Governor-General of India. The right to constitutional remedies is the only absolute right mentioned in the Indian Constitution. So the answer is C. The right to constitutional remedies is guaranteed by Article 32 of the Constitution. It gives the citizens the right to approach the Supreme Court for the enforcement of their fundamental rights. The other rights mentioned in the question are not absolute. The right to equality is subject to reasonable classification. The right to freedom of religion is subject to public order, morality, and health. And the right to get equal pay for equal work is subject to the terms of employment. The right to constitutional remedies is absolute because it is essential for the protection of the other fundamental rights. Without the right to approach the Supreme Court, the other rights would be meaningless. The Supreme Court has held that the right to constitutional remedies is a basic feature of the Constitution and cannot be taken away by Parliament. This means that Parliament cannot amend the Constitution to take away the right to constitutional remedies. The right to constitutional remedies is a powerful tool that can be used by citizens to protect their fundamental rights. It is a guarantee that the citizens will have access to justice, even if the government violates their rights.